Kara Gansmann is with us today. Karen devotes her entire practice to elder law and estate planning in the Wilmington office of Cranfill, Sumner. Kara is especially well suited for this practice thanks to her strong interpersonal skills, diplomatic demeanor, and pragmatic approach to problem solving. She brings a solid sense of collegiality to her work with both clients and professionals. She leads a team of experienced professionals who also focus on elder care needs. The team's paralegals assist clients in matters ranging from probate to caregiver agreements to promissory notes or real estate deed transactions intended for long-term care planning. Kara's team also includes a certified geriatric care senior advisor who assists with placement into care facilities. The entire team understands the urgency and sometimes stress associated with seniors' needs. Kara frequently presents on elder law issues to community organizations, churches, and neighborhood associations across southeastern North Carolina. She's also a prolific writer on legal issues that affect seniors. She volunteers actively and supports local and state organizations that benefit seniors' lives. Kara is from North Carolina, where she grew up. She appreciates the value of a handshake, hard work, and trust placed in someone's words. She is a graduate of the University of North Carolina in Wilmington. She also has a BA from the University of North Dakota, and she received her law degree from the University of North Dakota with distinction in 2007, and she was also the editor-in-chief of the North Carolina Law Review while there. Currently, she is in the North Carolina Legal Elite Group for the estate and tax planning section. So please let me welcome Kara, and she will talk to us about estate planning.
I thank y'all so much for having me back. I think I was reminded this is the third time I've come to speak to your Nest organization, and every time I learned something more, that this group has only been in existence for 5 years, and I hear about all the wonderful things you do. One of the nicest things I learned last time I was here is that there are just as many volunteers as there are people receiving the services through the Nest organization, and that tells me a lot about you all as a community, so much so that I actually looked to see if I could create something in my own neighborhood, and I just think the world of this group. So y'all are onto something special, and I'm glad to see it continuing. Thanks to Linda. I am welcome. I'm happy to be welcome back again, and I want to distinguish a couple of things. People always say, oh, you're an elder law attorney. Well, that's just like estate planning. And it is. It's very similar to estate planning. We use a lot of those same tools, like powers of attorney and wills or trusts. But what we're focusing on in elder law is not just preparing for when we pass away, how we pass our estate and our assets, but we're actually preparing for during your lifetime. How are we going to use these assets? Do we need to protect them? How are we going to use some of these tools to benefit you and make sure that your lives are enriched and that your needs are being met? And that's what's a little bit different from elder law than typical estate planning. And so as we talk today, we're going to talk a lot about estate planning documents, because in my mind, you can't focus on long-term care planning without having an estate plan in place. And if those estate planning documents include some of these components that we need for long-term care planning, that's built into a plan. And that's a little bit of elder law as well. So we will get started. And again, if we want to ask questions, I'll just encourage you to hold those questions till the end, right around the 4 o'clock hour. I'll kind of break, and we'll take questions at that time, and we'll pass the mic so that we hear everything. So there's a little bit of information about me in the slides that I'll slip through. The same materials contain some contact information for me that you will see in the slides as well. So getting started here, for me, the foundation of long-term care planning starts with your basic estate planning documents, powers of attorney for health, powers of attorney for finances. And it's because these are documents that are effective during your lifetime. In the event that you are unable to make decisions for health, or you are unable to make decisions transactionally for assets, finances, legal decisions, these are the documents that allow you to appoint someone that you trust to make these decisions. A lot of people know what these are, and so I want to focus a little bit on some of the nuances about why these are important. Because without them, if long-term care is important and planning for that is important to you, you can't make those choices for yourself. We are having to rely on these documents. So touching briefly on a healthcare power of attorney, these are going to be specific to each state. There's going to be different components to these, but what we want is you to be able to appoint someone that you trust to be able to make decisions for your health, your medical needs. In the event that you're unable to make those choices for yourself, you're incapacitated, this is someone that you trust to be able to make those choices for you. I include these in a single document. They can be separate documents. And so in my document, I have several components to that, which may include not just appointing an agent, but that living will component. That's what a lot of people ask about. Sometimes they're called advanced directives. A lot of times my clients call these DNRs, and they are not legally DNRs. And I think you all may have heard somebody talk about that recently, or you will hear somebody talk about that recently. But people tend to equate the living will with a DNR, wholly separate documents. The living will that I prepare is a legal document, one that we're talking prospectively in 3 different situations. If you are incapacitated and you need life support and you are terminally ill, or you're in a permanent vegetative state, or if you have advanced dementia, this living will allows you to tell your agents how to make that decision, how you want life support to be received, if you want it received at all or not. And so this is a very loving gesture that you are guiding your agent as they may make decisions for you prospectively in the future. We want to appoint not just an agent, but a successor agent. We don't want to bank on the fact that the one and only person you trust is going to be there for you. We want to plan for that succession. So sometimes naming several layers of people, that's important. HIPAA is a big component of my documents too, being able to identify who you will allow to speak with your doctors and your providers. Typically, I want to include those agents, but sometimes you want to expand that group. Sometimes you want your siblings to be able to speak with your providers because your siblings have a medical experience. Sometimes your children are your agents, having them on that group. And this is intended to supersede, or expand what's at a doctor's office. So you may typically sign HIPAA paperwork at your doctor's office pretty frequently. This is intended to expand what you've put in place with your doctor. So a lot of times people will come to me, and this is a question we'll kind of pick at throughout our time together. I got an out-of-state power of attorney for health. And we'll talk about this for each and every document. If you have an out-of-state healthcare power of attorney, now what? Well, I don't know. It's going to really depend on the circumstances. But what I have heard, and this is in years past, sometimes our local providers will not accept those. And I don't understand why. And from a policy perspective, I think that's unfair. There may be people who can't execute a new power of attorney. But if you have an out-of-state document, it is going to be written with that state's laws. And so typically I will say there are a couple reasons why those present challenges. Time and money. Time is if you are seeking care at a hospital, they urgently want to meet your care needs. If they have to have their legal department, there's your money, review an out-of-state document is going to result in a delay in care. Sometimes doctors don't always understand exactly what one state says compared to what they know North Carolina state law says, especially for a living will. So they need their legal department to review it so that everyone's acting appropriately under that document. And so truly having an out-of-state document can result in a delay in your care. I knew at least a few years ago, Novant was not accepting out-of-state powers of attorney for health, which I think is unfortunate. That's actually resulted in me seeing a couple clients on the fly so that they could have the surgeries they needed and have a new power of attorney executed. but it was simply because they knew that Novant was not going to accept their out-of-state healthcare power of attorney. These are actually free documents. You can find these online. There's a statutory form in North Carolina. And from a public policy perspective, that's why we want this so widely accessible to people, because we do not want someone to go without a healthcare power of attorney, because what happens if you don't have one? If you become incapacitated and there is no legal document in place that you are appointing someone to make decisions for you, a court gets to make that decision, and a court-appointed guardianship. It is a public hearing. A clerk of court, not even a judge, a clerk of court makes these decisions and appoints someone, finding you incapacitated. And so this is such an important document. It's free. You can find it online. That doesn't mean that I don't like mine better. Mine are not free, but I like mine better. So next, financial powers of attorney, often called durable general powers of attorney. These are critical to allowing someone that you appoint as an agent to handle transactional things for you. Assets like bank accounts, selling cars, buying cars, selling houses even, filing tax returns for you, endorsing checks, paying your bills, making claims against insurance, including long-term care insurance. Being able to handle lots of the things that you might handle for yourself on a day-to-day, but if you can't, we want someone that you're appointing who is vested with the abilities and the authority to act on your behalf as an agent. Here in North Carolina, there is a statutory short form. These are very, very basic. They are simple documents. They are not going to do very much beyond what the minimum that the law allows. So when I say statutory short form, everyone says, well, do you have a long form? Well, I do have a long form, but we don't call it that. We call it the same thing, a durable general power of attorney. Mine just happens to be a lot more complex. But the reason we want some of that complexity is because the statutory short form, the state's form, is not going to consider all the things that I want for my clients. Sometimes my clients don't need all the bells and whistles, but more often than not, they do. Because here's where the statutory short form is very deficient. It's not going to allow you to determine when your agents can act. Sometimes you want what's called a springing power of attorney, where you are limiting when that agent can act on your behalf. Maybe you don't want them acting until you're incapacitated. Maybe you don't want them acting until some other contingent event has come up. So being able to limit when your agent can act is important. Gifting is a big strategy that I include in my powers of attorney, and I include what are called a number of hot powers in my powers of attorney. These are complex decisions. They require good discussion with an attorney. These are things that you shouldn't take on by yourself. But these hot powers are beneficial for that long-term care planning, what we're going to talk about a little bit later. And this is where that statutory short form is going to be very deficient. You're not going to be able to make significant gifts in your power of attorney if it's the statutory short form. In a more complex, there's going to be components for gifting, but there's going to be checks and balances. And we'll get to why gifting can be important later. But in general, you can't give gifts under this short form unless you've given authority, and that authority has to be specifically given. And you probably want to put some guardrails in place for your agent if they are going to make gifts. Same for other long-term care planning concepts, like changing ownership on things to be right of survivorship. Thinking your house. There are times that you may want to change the ownership on your home to preserve it for long-term care planning purposes. If you can't do it yourself, I want your power of attorney agent to be able to do it, but I want some guardrails in place because I don't want them adding just anybody. I want to make it consistent with your estate plan. And so having some of these powers, they're hot powers because they have the detrimental impact of changing your estate plan, which means you got to trust the agent and what they're doing anyway. But you want to have those guardrails in place, the checks and balances system. And that's what a more complex power of attorney is going to do compared to this short form that the state has. So when you have a power of attorney for finances, this is how I distinguish from healthcare powers of attorney. You're also avoiding a court-appointed guardianship. In the event that you became incapacitated, This is a document that's allowing someone to step right in without the need for a clerk of court to intervene. Now, here's where, again, with that question about, well, I have an out-of-state power of attorney. This is one that I don't see a lot of pushback on. Banks will recognize powers of attorney quite a bit. And so if you have an out-of-state one, it really depends on the terms of what that says. If it refers to, let's say, Pennsylvania law or New York law, I'm not licensed there. So if we're limited by that state's laws, it means we may have to get an attorney in that state to inform what those laws are for your agent to be able to act appropriately. So there is a new Power of Attorney Act here in North Carolina. I say it's new, it's almost 8 years old now. But that has been a great thing. We have, in North Carolina, have taken the Uniform North Carolina Power of Attorney Act, and we have really made this a wonderful tool for us, which has allowed practitioners in the state to be able to use these and to set up some parameters when these can be rejected. And so what we have found in the state is with attorneys is that banks aren't rejecting these nearly as much as they were. And there's only some discrete reasons why these should be rejected. So this new Power of Attorney Act has been a helpful thing for my practice. Something I want to touch on, because I hear this probably twice a week. I don't need a power of attorney. I'm just going to add my number one daughter, my number one son to my bank account. They're going to pay my bills. That makes it very convenient. And I'm not going to ask for volunteers who have done this themselves. I never recommend adding anybody to a bank account beyond your spouse, if you have a spouse. And the reason is because a power of attorney can do all of those things and protect you better than making someone else a joint owner with you. And so often when I say, I really don't recommend that, that's not a good idea, I get lots of pushback. Well, you don't know my son and you don't know my daughter, and I'm exactly right, I don't, which is why I want to use a power of attorney. So the reasons why I don't want this is because when you're adding anybody to your bank account who's not a spouse, you're allowing them to be an owner with you. For one, that could be a gifting thing under IRS rules. But for two, you've just made them an owner of property without any rules in place about what they can and can't do with your money, which is now their money. So what if they steal from you? And that's when my client will say, oh, you don't know my son or my daughter, they're not going to steal from me. And I'm sure that's true, but the problem is that they may unintentionally steal from you. I'm not suggesting your kids are thieves, but they may unintentionally steal from you. And it goes like this. How many of y'all lived in bigger cities before you moved here? Was the traffic bad? Yeah. So if there's a car accident and your child is in a car accident, and now they're being sued for causing that car accident, and their name is on your bank account with your life savings, guess whose bank account's getting frozen until the lawsuit figures out whose money is actually in that account? So unintentionally stealing from mom and dad is probably not something anybody thinks about. Other reasons, how many of y'all don't like your children's spouses? And you don't have to answer that. But let's think this one through. You've added an adult child to your bank account purely for convenience. You don't like that child's spouse, but your child has a durable general power of attorney that appointed their spouse to be able to access and control bank accounts in your child's name, which happens to include your bank account with your life savings that you share with your adult child. That's a good reason not to add your children to your bank account. Other reasons I don't like to add children to bank accounts are, well, you are unintentionally, or maybe it's intentional, disinheriting your other children. So if you have more than one child, I have one child. But if you have more than one child and your intent is this account gets divided among all my children on my passing, and I've added this number one son, number one daughter to this account, and they're going to do the right thing because they always do. It's not always the case. You've just disinherited your other children from receiving that account because presuming your child survives you, that's their money. And even if they want to do the right thing, because they will, they're your number one son or daughter, that's going to create a tax issue for them possibly. And so there's reasons we don't want to add people to bank accounts just for that convenience, especially when a power of attorney solves all those problems without making them an owner on an account. Keeps them under this role as agent without being an owner, still being able to access your accounts for you, pay your bills. So I want to shift gears a little bit, because the other question I get asked quite frequently is, all right, do I need a will or do I need a trust? Because then they'll say, all my neighbors, all my friends, all my siblings, we all have trusts, and I'm the only one without a trust, and now I think I need one too because I'm like them. The question is, I don't know without asking far more personal information about you, your assets, your family members, to be able to determine whether a will or a trust is more appropriate for you. But what I will talk about today is, well, what does this do? And what's the vehicle that this document will take? If you have just a will, sometimes people say, do I even need a will? I generally say yes. There's very few instances when I don't think a will is really that important. A will can be important for you in appointing an executor, someone to handle your estate when you're gone. A will is important in identifying how these assets are distributed, who gets them. And those are the main concepts. Because if you don't have a will and there's something in your name only, it's not jointly owned, it doesn't have beneficiaries, it's not in a trust, that's going to pass through probate. So, and if you don't have a will and you've passed away, then North Carolina has an idea of what North Carolina thinks your intestate estate should look like. And this is a set of laws that says, oh, if you passed away and this is what you own, this is how it's going to pass. And it's not all passing to your spouse, believe it or not. So if you're married and you think it all passes to your spouse anyway, you are wrong. Especially if you've got kids from another relationship, you're really wrong. And so intestacy laws start to become important in determining whether you need an estate plan, whether a will or a trust is important. Because if you don't want to follow North Carolina's idea, then creating a will does start to become important. It starts to become important too because I don't know if you all have young people in your lives, like I have a 15-year-old son. He's too young to inherit money, shouldn't inherit money, even if he's 18. He should wait at least until 25, and if he's like my husband and I think he's going to be, probably 30. And that's okay. He's a young guy right now, and he's a knucklehead, but age-appropriate knucklehead. So there's reasons we want to create an estate plan with that in mind. Let him mature appropriately. And so whether that's created in a will or that's created in a trust, that's something we'll get to. So being able to appoint guardians for minors is important in a will. That may not be as appropriate for this generation, but it's important to have a will that does allow you to appoint guardians for people. Because this is giving you the control that you want. So another concept people come to me with, a myth that they say, well, I have a will. What do you mean I have to go through probate? I have a will already. And that's where I think that person is uninformed, because a lot of times when you have a will, you are definitely going through probate. But again, it's with the assets that are just in your name and your name only. What passes through probate are not things that you own jointly with other people. These are not assets like life insurance policies or retirement accounts or other accounts where you have named beneficiaries. These are not assets in trust. So there are things that don't pass through probate because there are other mechanisms, joint ownership, trust, or beneficiary designations that are avoiding all kinds of probate wills and trusts just by the way they're set up. But the probate process is actually a legal process, where here in this area, in Bolivia, the clerk of court in the estates division will accept a death certificate and a will if there is one. If there isn't one, then it's an intestate estate, and we apply those North Carolina laws. And someone who is taking that death certificate down to Bolivia is applying typically to be an executor of the estate or administrator of the estate. I'm going to use that word interchangeably, but executor is the person who gets to be appointed by the court to handle the estate, wind up that person's affairs, pay any final bills to creditors if needed. And if there is a creditor, so if you die owing money to somebody, here in North Carolina, if you have an estate that we believe is valued at $20,000 or more, it's what attorneys typically call a full probate, meaning we want to make sure that all creditors are informed of your passing. We will run a notice to creditors in the newspaper, and that's giving any creditor, anybody who believes you owe them money, 90 days. You got 90 days to come forward, creditor. If you don't come forward in that time frame, your claim, your judgment is barred. We don't owe you money anymore if you don't come. And that's a good thing. I actually see probate as a good thing because this is fleshing out creditors where North Carolina gives you a 2-year period to come forward. We're limiting that to a 90-day process. But once that 90-day process is done, any creditors are paid from the assets of the estate. Tax returns are filed if needed. We get a refund if needed. And then everything is divided pursuant to the will, pursuant to the law. The clerk of court supervises the whole process. And I would say, in general, my estates probably last 4 to 6 months. On occasion, if we are waiting longer than that, it's because we have an IRS issue. Maybe we're waiting on a refund. Refunds from the feds take a little bit longer. They're sending out paper checks. They're not going to send it electronically or direct deposit. So sometimes it takes a little bit longer because of the feds, but that doesn't mean everything's frozen. It doesn't mean that. I know that's a misconcept that a lot of people will come to me about. That doesn't mean that we can't make partial distributions from the estate. We certainly can. And so from my perspective, and this is probably a unique perspective, I don't think probate is really that big of a deal, at least here in North Carolina. Now, other states, it can be very expensive, very lengthy. And if you've had bad experiences, I can understand why. But here in North Carolina, it's pretty smooth. It doesn't cost that much. Here in North Carolina, there are probate fees that the clerk of court will assess. Again, based on the value of the assets that are passing through probate. It's a very small percent, 0.04%, and it's capped at $6,000. So the state of North Carolina won't take more. That's for estates that are 1.5 million or greater. So one of the things I think is surprising to me, especially if you're not from here, is when you move here and you find out that North Carolina does not have a death tax. And I don't know if that was news to some of y'all or if this is news now, but we here in North Carolina on the state level, we do not have a death tax. Other states do. And unless you pass away with 14 million or more, we're really not worried too much about federal estate taxes either. If that's you and your net worth, then I'll probably refer you to one of my friends. I do not work with the high net worth folks as frequently, and that's by design and certainly by choice. But it is good news on the state level, we don't have that. And something I want to touch on is what this ancillary estate or ancillary probate. That is where if you have real estate outside of North Carolina, you will have to have probate here as a domiciliary state. And then you will have to have probate in the other state, wherever that real estate lies. And sometimes I have people reach out to me because they passed away in another state, but they own property here in North Carolina and they need an ancillary probate. It's a little bit of an abbreviated process, but here we still have to go through that 90-day notice to creditors period. And so an ancillary probate can just be extra work. And if you have real estate maybe in one of those more expensive states, maybe in the north where probate fees and it can take a long time, that's when you start to worry about, well, what are the costs of going through probate when I have real estate here and I have real estate in this other place? And that's when I start wondering, well, maybe a trust is a good option. So this is the number one question. Do I need a will? Do I need a trust? And I won't be able to answer that for you today because I don't know enough about you personally, but I can talk you through how I look at these considerations. I think about, this is a dollars and cents conversation. On the one hand, I kind of add up in my head what is passing through what could be probate with a will-based plan. Sometimes you're paying more in probate fees than you will for a trust. And if that's the case, then, trust might be an easy answer. Sometimes you'll pay less in probate fees than you would for a trust, and sometimes that is the easy answer. But that's not all of the equation. That's just on the dollars part of that question. When we're talking about cents, I'm talking about what makes sense, not nickels and dimes. And so then I need to ask about, well, who are the people involved? What's their situation? What do we need to plan for? So sometimes if you have a blended family and you want to provide for a spouse, but you also want to provide for children from another relationship, trust might make more sense. Or if you've got people who are not responsible, and I count my son as part of that because he's just 15. He's not financially responsible yet, and he won't be for quite some time, and that's okay. But sometimes we have adults who aren't responsible. Maybe they just aren't good at handling money. Maybe they have special needs. Maybe they're chemically dependent on drugs or alcohol. Maybe they're in weird marriages and they've got a spouse who we don't like. We don't want that person to have a little more extra money. And so it's kind of thinking about, are the people who are inheriting from me, are we holding their shares in a trust? And if that's the case, then you having a living trust yourself might start to make sense. So we're not routing things through probate just to land in a trust for someone else. You have a living trust on your own. We're avoiding probate. That's a great thing. But the ultimate goal is that we're providing everything in separate trusts for other people. And so that's part of that dollars and cents conversation. And remember, we talked earlier about having real estate in another state. Well, let's add that to your trust. Let's avoid probate here and in that other place. So starting to have a trust sometimes makes sense for people. And so then you can route assets to the trust. You can name the trust as a beneficiary. You can fund the trust by retitling your assets, your accounts, sometimes your deeds to your property, and really make that trust work a little bit harder for you. And the benefit is that you're avoiding probate, but it really depends on the kinds of assets you have, whether they can go into trust. Things like IRAs, TSP accounts, 401ks, you can't retitle the names of those into the trust at the moment, but you can name the trust as a beneficiary. Sometimes there's tax reasons to do that or avoid that. So that's very dependent on your specific needs and what your wishes are. So when people ask me, we start thinking a little more about a trust and does this benefit you? How does it work? A trust is a legal entity. You are creating this. The work that I'm doing, I'm creating a bunch of paperwork that you end up signing. But treat it like an instruction manual. That's really what we're creating. We're telling people who gets to be in charge of this money at any point during your lifetime, after you've passed, what they need to be doing with this money. Does it get used for your needs, your spouse's needs, dependents? If you're incapacitated, you get to put those rules in place too. But really, after you've passed, very similar to a will, you get to identify, how are these assets handled? How are they divided? Does this piece of property go to one person? The other property goes to somebody else. The money is divided or held in trust for someone. When do they get that money? Who's in charge of it? Is there certain rules in place? And so these are all the things that you get to set into motion as part of your estate plan and creating a living trust. Think of it like a piggy bank. Sometimes people think of it like a bucket or a basket. It carries things. You're crossing the finish line without going through probate. If you've titled things in the name of your trust, you've funded the trust. So sometimes people will say, well, what are the circumstances you look for to determine when a trust is appropriate? Sometimes you want it to receive life insurance funds for when a spouse passes. Those are ILITs, irrevocable life insurance trusts. That's one kind of a trust. Sometimes you want to hold back money for your problem children or people, your kids who are married to people who are problems. Sometimes you want to hold money back for young people who aren't quite mature or responsible. Sometimes you've got folks with chemical dependencies. Sometimes you've got blended marriages. Sometimes you have people with special needs. And so these are all the kinds of people who may ultimately have trusts as part of your plan, and having a revocable trust for your plan serves your needs to get your assets to these people. And it's really important to notice that a revocable trust is not protected from creditors. So as we start going towards this long-term care planning, this asset protection planning, a lot of times people will say, well, I like the idea of a trust for asset protection, but I want a revocable trust. A revocable trust is not asset protection. It's an extension of you. And so it is not protected from creditors. And that's very key, because we're going to talk later about irrevocable trusts. When you have a trust, you got to think about who's in charge when you're not. And if you're not in charge, it's because you're incapacitated or you've passed away. You got to pick a trustee. And who those people are critical. I know a lot of folks want to choose a sibling because they appreciate siblings. And I think that's great that you have trust in your sibling, but that trust, that requires that person to be around a long time. And sometimes that person may experience health issues or pass away even before you. And if you're not able to update your trust, so we start to think about, okay, well, we need a trustee who's going to be here for a long time. A corporate trustee may be a good fit for those particular circumstances. Banks, there are trust companies out there. There are things that we would need to talk about. How long do we need a trustee to be in place for? And what are their fees? And that's important to have that conversation too. Sometimes people want trusted friends. Well, we got to think about, is that going to burden them? What are their relationships like with the people involved? Is that going to be a difficult family Thanksgiving dinner when one person's sitting as a trustee over somebody else's money? Sometimes you want to think about an attorney being a trustee. That's not a job I really like to do. I do it very, very infrequently, only when necessary, but it's something to think about. And then I throw in this idea of a trust protector, because someone says, well, if I'm gone and I'm holding things in trust for this other person and we have a trustee, how do we know everybody's going to work this out right? Having a trust protector is someone that you can appoint who is not a trustee but can kind of guide everybody. So those are different roles too to think about. I don't think I can underscore enough, while everyone asks about trust, what they don't hear, even though we talk about it, even though I write to them about it, funding the trust is the bigger important part about having a trust. Your job is not done once you've created a trust with your attorney. You have to fund it. And funding it means you're making your trust work for you. If you don't fund the trust, if you don't retitle those accounts into the name of the trust, if you don't transfer your real estate by deed into the trust, you're doing yourselves a disservice. You have an empty box, an empty shell. And when you pass away and everything goes into probate, your family is going to say, why didn't they fund the trust? And that will be my first question. I wonder why they didn't fund their trust. Because that is so critical. Your work is not done. If you have a trust, you need to fund it. So what I want to shift gears, what we've talked about so far are estate planning documents, powers of attorney, wills, and trusts. You can't do any long-term care planning or asset protection planning if you don't have those basic foundational elements in place. And for me, that's namely the powers of attorney. So when we get to the idea of long-term care planning, nobody wants to be in long-term care, and I respect that. But there are times that we can't choose that. And if we find ourselves needing long-term care, we now need to figure out, how do we pay for that? And so there's really only a few ways to pay for long-term care. You either self-fund and private pay because you've got the funds to do that. You can have long-term care insurance, and to qualify for that, there's a medical component, and it's still very cost prohibitive for many people. But if you have it, it's a great tool in our tool belt. If you don't have it, don't feel left out. A lot of people don't, and there are still opportunities. If we have veterans, there are veterans benefits for long-term care for wartime veterans as well as the spouses of wartime veterans. It will not pay entirely for long-term care, but it will provide a special pension that helps defray those care costs. Those veterans earned it. And then we have public benefits like Medicaid. And there's a reason we have Medicaid, is because people need it. Now, some planning tools that we might use would be care contracts, which we'll kind of circle back on later. But one of the biggest questions people tend to talk to me about is, well, I've got Medicare. Medicare is going to pay for everything. And Medicare does not pay for everything when you need long-term care. Medicare will pay for your services, your hospital visits. It will pay for doctors and nursing visits. But when you need long-term care, it's not going to pay for the room and board at a facility. And that's where you'll either have to figure that out and pay privately or have long-term care insurance, or you qualify for a public benefit like Medicaid. Medicaid, there's a belief that this is for poor people, and a myth that you will not qualify for Medicaid. And so the kinds of people who need Medicaid are those who have qualified for Medicaid, usually by having a medical need that qualifies for Medicaid, but also being financially qualified for Medicaid. And so many of you might sit in this room and say, well, I'll never financially qualify for Medicaid. I've got too much. And that may be the case. You may choose not to qualify for Medicaid, which means you may be self-paying. But there's a number of people who actually choose to qualify for Medicaid, even having substantial sums of money, because we're looking to accelerate their eligibility for Medicaid by conducting asset protection so that they are not spending everything that they own on their care. And that's where there's a lot of different schools of thought on who needs to qualify for Medicaid, and it's a philosophy. If it's not your philosophy, that's okay. So when you qualify for Medicaid here in North Carolina, you have to be medically eligible by needing skilled nursing care, meaning the highest level of care. And then if you are needing to qualify financially, there's two different ways to qualify. If you're an unmarried applicant, then it's very easy. All of your assets, all of your cash, all of your money needs to be spent down to $2,000. You can still have a home, you can still have a car, and you can still have a prepaid burial plan. And that's that. Once you've hit those numbers, then you can get Medicaid. Again, you have to be in skilled care. And you can't have made gifts in the preceding 5 years. If you are a married person, that's when I say couples, then then it's a little bit different. The person who is applying for Medicaid, their assets have to be spent down to $2,000. Their spouse can keep up to half of the assets with a max of $160,000. And then they can still have a house, a car, and a prepaid burial. And then that person who needs Medicaid, that married person, can still qualify for Medicaid at that point. Again, assuming that they did not make gifts in the preceding 5 years. That's what's called that 5-year look-back period. There are what we call exempt assets, and those are things that are jointly owned. So if you're a married couple and you own the house together, that's an exempt asset. There are also some other exempt assets. If you own something or you've given things to a disabled child, that's exempt too. But when we start talking about giving things away, if you don't have a disabled child, then that's a gift that would, under Medicaid's 5-year look-back period, would jeopardize and penalize you. So another question I get asked commonly is, Mom's about to enter the nursing home, we got to get the house out of her name. Or we need to get everything out of Mom and Dad's name because somebody's sick and needs care. And that is poor planning to just do that, because you got to start thinking in mind about those look-back periods. And we got to start thinking, does Mom or Dad have the capacity to do that anyway? And if the answer is no, then what does their power of attorney say? And going back to that statutory short form power of attorney, that's not going to let you give things away. So that's where planning starts to become really important. So when you apply for Medicaid, from the date you enter long-term care, that's what's called a snapshot. And that's that 5-year period preceding that you can't have made gifts. That's that 5-year look-back period. So gifts are anything that you didn't receive fair compensation for. If you've given something away. And so a common example, someone will say to me, well, I'm just going to give my house to my niece for $10 or $1 or whatever. Unless that house is actually valued at $10, that's a gift. And so, or I just gave my car to my son, he needed it, but that's still a gift. If your son is an adult, that's a gift. Giving away money, that's a gift. If you're not getting fair compensation back, it's a gift that under Medicaid's look-back period, if you've applied for Medicaid within 5 years of that gift, that will be sanctionable. It will penalize you with a waiting period. And that waiting period means you already need care. You've already qualified financially as being within that $2,000 range. And now you got to wait longer because you gave something away. And that's how Medicaid makes sure that, well, they penalize you. You gave away care. So you can make exempt transfers. And so this is where we start thinking about loopholes. You know, if you pay taxes, you're always looking for a good loophole. You don't want to pay more taxes. Well, that's what this is too. We don't pay everything we have. If we're going to qualify for Medicaid and we want to accelerate our eligibility for Medicaid, well, let's look for some loopholes here. What are some things we can do? Exempt transfers. I want to give things to my spouse. I'm going to give the whole house to my spouse. That sounds great. It sounds great because remember that house is an exempt asset. You can still have a house and be on Medicaid. Now, the problem is Medicaid will come and take that house back when both of y'all have passed. But let's talk about, let's give the whole house to your spouse. Your spouse is the healthy one. You're the one who might need care. Give it to your spouse and have that spouse go create an irrevocable trust to protect that house. Or money. And so we start thinking about these loopholes. Exempt transfers to spouses, always fine. Not worried about the 5-year look back. You can give something to your spouse the next day and go qualify for Medicaid. Transfers to disabled children, same thing. It's an exempt transfer. Transfers to anybody else, though, it's going to create that penalty. So those would be non-exempt transfers. So oftentimes people will say, well, what do we do? Well, sometimes we spend down our money to qualify until we reach those points. And the penalty is a divisor of $12,000. So take the amount that you've given away, divide it by 12,000. That's going to equate to the number of months that Medicaid makes you wait when you're otherwise qualified before they will kick in the benefits for you. And it starts as soon as you're eligible. So how are some things that we protect assets? Irrevocable trusts to protect assets, far different from revocable trusts. Some people want to disinherit a spouse. I don't want that. I want to create a supplemental needs trust for your spouse to prevent Medicaid's clawback. I create that in your plan. There's 2 ways to qualify for Medicaid, though. One is advanced planning, where we're being prospective about our planning, using irrevocable trusts, ones that can't be changed. These are also trusts you are not in charge of. You are not your own trustee, and you may not be the beneficiary either, but you're protecting assets. Or crisis planning. No one likes that idea of crisis. Nobody likes that word crisis. But what that means is we've waited. We didn't do prospective planning or advanced planning. Now we're in a moment of crisis where there's an immediate need for care and a pretty quick desire to qualify for Medicaid, not spending everything down. So in crisis planning, I usually tell people, We can protect the house right now under our current laws, and we can protect about half the cash assets, not all. And then with advanced planning, we can protect quite a bit of money. We can protect real estate. We can protect property. And this is where we might use care contracts. If we do have that number one son, number one daughter who wants to help you, sometimes we will have a caregiver agreement or a care contract that allows you to pay your child for the work they're probably helping you with already in the home, driving you to a doctor, doing your laundry, shopping, cooking, cleaning. If you're starting to receive help from a child, you can't just pay that child. That's a gift, remember? But if we create a care contract, that's a legally enforceable contract. Here's our loophole. Let me pay you, number one son or daughter, for all the work that you're already doing for me. And Medicaid will not see that as a gift because it is legally enforceable. They're entitled to that. So this is where contracts start to come in handy. Sometimes we'll use annuities to get money out of your name as an asset and have it come in as a short-term income stream for a spouse in order to qualify you faster for Medicaid. Sometimes we use a promissory note. There's a theory we call half-loaf gifting. I said in crisis we get to protect about half your assets. That's where I'm relying on that power of attorney, that hot power of gifting. I want to be able to gift significant funds, get it out of your name, and then I'm going to loan the other half to someone reliable who is going to pay it back. I'm going to get you down to $2,000. I apply for Medicaid. Medicaid's going to say, well, gosh, you just gave away half your assets. That was 3 days ago. You know about that look-back period, that 5 years. We're going to deny you and start that penalty period. And I'm going to say, great, because that promissory note is going to pay back in time just appropriately with that penalty period so that when that promissory note is paid back, your care through that penalty period has been paid out, and now you're on Medicaid much faster. That's where we've saved about half of your money. But we can't do it unless you're capable of doing it yourself or that power of attorney you have allows you to make significant gifts. I want to be mindful of our time and talk just briefly about irrevocable trust because we talked earlier about revocable trust. An irrevocable trust is just that. You can't change it. It's irrevocable. It is one that you are creating. You are not a trustee. Someone else is. Someone you trust, hopefully. You are not a beneficiary of this trust, although you might reserve the right to live in a home. But you don't get the benefit of receiving income or even principal from this trust. The beneficiaries are people that you choose, but it's not you. You do retain several powers. Sometimes it's the ability to earn the interest off any funds. It's the ability to live in the home, and it's the ability to fire the trustee. So if you don't like the trustee you've chosen, you have the authority to be able to fire that person. But an irrevocable trust is a great planning tool. If you can get behind the concept that you aren't in control of these assets anymore, that you're making a gift to somebody, is a great asset protection tool to protect it. You got to do these far outside of the Medicaid look-back period, so well before 5 years. But this is a great tool. These are accepted in all 50 states. And it protects from creditors. It protects probate, which isn't our main goal. It allows you to qualify for Medicaid a little bit sooner. It prevents clawback by Medicaid. And then last, I want to talk about protecting the house because I talked earlier about, well, you can have a house, you can qualify for Medicaid. But the problem is under Medicaid's estate recovery rules, there are federal laws. Each state applies these federal laws. If you pass away and you own a piece of property or anything in your estate really, and you've been a Medicaid recipient, there is a right to estate recovery. Each state can pursue to reclaim those costs that they've spent for your long-term care. And so obviously that's usually just a house if you haven't done something further to protect the house. And that protection is either through an irrevocable trust. But there's some other ways in crisis that we do plan to protect the house to prevent this estate recovery. Sometimes it's through these exempt transfers, like to a disabled person's disabled child. But more often than not, we will conduct what we call deed transactions that are either 1% in nature, where we have your children, as an example, purchase 1% of the home with you. It's not a gift. They've purchased it. We've changed the ownership on the deed so that you now own a piece of property with your children. And there's some risks in that, because remember I talked earlier about having a bank account with your child. Those risks are still there. So this is why this is a crisis planning move. This is our last-ditch effort to protect the house. And then we do another 1% transaction where we're changing the children to be joint tenants with you with right of survivorship. The concept that they will probably survive you is an estate planning tool for long-term care that is currently allowed under our North Carolina legislature. I can't say it's always going to be an available option. It is on the radar of our legislature. I don't know what would be grandfathered in the future, but this can be a very valuable planning tool. This is one that I don't do unless there's a moment of crisis. So don't ask me to come do this for you if you're not in a nursing home. There are attorneys who will do that. It's just my personal preference is that there's too many risks, and I don't want to do something outside of the need for this. And then again, we talked about that caretaker child, that care contract earlier. Well, what if you have a child who has come to live in your home for a period of 2 years or more, and they have provided care to you, and a doctor has even said, gosh, if it wasn't this child's care, you would have been in a nursing home 2 years ago. If you put all this into a legal contract, a care contract, under federal laws, you can transfer the whole house to that caretaker child, even within that 5-year look-back period. Having that care contract in place requires that child to work hard. They're probably working hard if they live with you and that you've needed care that kept you out of a nursing home for 2 years. But that caretaker child exception is a phenomenal tool. If you have a child who's willing to move in with you and take care of you, and you can transfer the house to that child. So I think I've timed this pretty well. And this is a point when we can talk about questions. I'm happy to take questions. Meg has a microphone, and she will ask you to use a microphone so that we can capture those questions.
Thank you for your information. I'm just wondering, are retirement funds or IRAs, are those part of the $2,000 that we're only allowed to have?
So that's a good question. Every state is going to have different rules on that. And so here in North Carolina, retirement funds like IRAs are part of the countable assets. So it's within the amount of the $2,000.
So we'd have no income if that's if we don't
Correct.
have pensions. Wow.
Correct.
That's loud.
I'm sorry. Can you speak specifically about widowed people? Like you have a trust in place already, you have a will in place, but you've never made any changes since the spouse passed. Do those documents need to be updated, or will they just already contain the wording we need?
So I like that question because on the one hand, I always welcome an opportunity to review what these documents say. Sometimes if you've planned well and you have successors in place and the plan hasn't really changed since your spouse has passed away, sometimes it's just a great opportunity to verify that the plan you think is in place is still the plan that you want. And you may not need to change anything, but it's worthwhile to have a peek at it and just make sure. If it's been a long time especially.
When you talk about Medicaid and a nursing home, is that a private nursing home or is it a government-run nursing home?
So believe it or not, this may be a surprise to most of you. Most of the nursing homes in this area, skilled nursing homes, will accept Medicaid, even if they take private patients as well. Even the really nice nursing homes in this area, many of them will take Medicaid. There's a few number of beds reserved for Medicaid at most of our facilities.
Hi, I read about transfer on death deeds that
So we get those questions quite a bit. We don't have them here in North
No,
Carolina.
that's what I want.
I think Arizona, some of these other states have them, and people love them, apparently.
Hi. Do you need an elder law attorney to set up a revocable trust?
Not necessarily. So an estate planning attorney can create those just as much.
Oh, but you need an attorney.
I would not advise doing it yourself.
You didn't talk about choosing an executor. And my kids are scattered across the country. They and their spouses both work. They have children who are in school. They don't really have the time to come here and do a complicated estate settlement. Do you recommend we retain an attorney in advance to be the executor, or how should we handle that?
So my thought is name the people you trust. If those are your children, go ahead and name them. And I recognize if your kids are still working and they have families, that can feel burdensome, especially if they don't live here locally. They're going to have to retain someone to serve as a registered process agent anyway. That's usually an attorney. And they will have to secure a bond if they're from out of state as well. And so, but number one, choose the people you trust. If that's your kids, they may retain an attorney. And I say that because I'm an attorney and I like working with them. But by the same token, I haven't met a lot of my clients for probates who are executors of parents' estates because they live out of state. I've never met them face to face. Most of our work is conducted by email or mail. There's very little that they physically have to be present for to do the work of as an executor. They may want to come to the home and go through some of the items in the home, but that doesn't require an attorney to be present. But if your kids do live out of state, they will have to secure a registered process agent. Someone who lives in North Carolina often will serve as that for our out-of-state executors. But in terms of having an attorney do this role and be appointed to this role, there are attorneys who probably do that. And I used to count myself as one of those people, but more and more, that's just not something I want to do. And I say that in earnesty because I don't think anyone wants to pay my hourly rates to go through their underwear drawer. We don't know each other well enough for me to do that. And so more and more, it's just not a job I'm feeling comfortable with. And that's just out of personal preference too. A lot of clients aren't keeping in touch with me with the way that I thought they should or would. And I'm losing track of the duties that I might need to be conducting if I don't get to see them as frequently. And so as a personal matter, I'm just choosing not to, but there may be attorneys who want to and will do that.